Redevelopment Agency meeting for August 23rd, 2011. May we have a roll call, please?
Agency members: Friedman.
Here.
Jarian. Quintero.
Here.
Weaver.
Here.
Chairman Manukian.
Here. Can we have your report?
The agenda for the August 23rd, 2011 regular meeting of the Glendale Redevelopment Agency was posted on Thursday, August 18th, 2011 on the bulletin board outside City Hall.
Thank you. What is next?
Next is minutes for approval.
So moved.
Is there a second?
Second.
There's a motion, a second, with no changes. The minutes will be approved as submitted. Or let's have a roll call since there was a motion, a second.
And just to note that I was absent last week.
Okay. August 16th, with the abstention of Mayor Friedman for August 16th.
Would you still?
Roll call, yes.
Sure. Agency members: Friedman.
Yes.
Jarian. Quintero.
Yes.
Weaver. Chairman Manukian.
Yes, next item, please.
Next item is oral communication. There was a card submitted, I believe, or was
Yes.
that? Yes. And same rules will apply with a 5-minute limit, no debate or decision, and the matter may be referred to staff through the executive director for investigation and report.
Thank you, Mr. Allen.
Thank you, Mr. Agency Chair and agency members. I'm Barry Allen. Several weeks ago, I had a communications back and forth with the State Controller's Office, and we discussed the fact that Glendale was not a city in excess of 200,000 population, and that the amount of money that was paid to the City Council, sitting as the redevelopment agency, was far in excess of what the amount should be, and that the issue needed to be addressed. And I understand it is being addressed, and also, but it's being addressed in one fashion. And I would like to suggest that as the City Council, sitting as a City Council, had agreed, and I believe it was 2001, to make the pension system retroactive 30 years, that they also, when they reimburse or when they stop their salaries from the redevelopment agency, that they look at the fact that maybe it should be retroactive to when the erroneous information forced their pay into the realm where it is, which I believe totals about, for the council sitting as the redevelopment agency, about $84,000 for everyone, for each of the 5 people sitting there. And I think that we really need to take a serious look at how that has happened. And we all know there's only one body in this country that is responsible for counting the people. It's the U.S. Census Bureau. And we also know that this council is aware of that, or the redevelopment agency is also aware of that, sitting as either the council or the RDA, that they know there's only one agency that is responsible for that. And I think that we need to take a serious look when that comes on the agenda, and for this body to acknowledge that it needs to look back as well as forward regarding the cost to the taxpayer of maintaining those high salaries. Thank you. I'm Barry Allen.
Thank you. I have no other cards. I believe that item's coming on the agenda next week.
Correct.
On the redevelopment agenda?
It's a joint
Thanks,
meeting.
actually, on your,
Yeah, it's a joint meeting, Mr. Manukian, for next week.
Next week,
Yes.
right?
because it's actually set by the city council.
City council agenda?
Yeah.
Okay. Just to be clear.
Yeah, just to be clear, an 84,000 figure was thrown out. I don't think we're even remotely close to, I'd say about half of that is the current pay.
Okay. Thank you. What is next, please?
On the business agenda at 6A is Director of Community Development regarding enforceable obligation payment schedule for the agency. At 6A1 is motion adopting the payment schedule.
And I think,
Okay.
Mr. Chair, if we can, do we want to try and take a B first? Yeah, I suggest we read in B and we take a B first.
Okay, let's go ahead.
6B is update and status report on litigation related to state budget legislation affecting redevelopment agencies, impact of Supreme Court stay on operations and activities of redevelopment agency. This is a oral report only.
Okay.
Mr. Chairman, members of the Redevelopment Agency, I'm Philip Lanzafame, Chief Assistant Director of Community Development. Thank you for taking the items out of order. We think it makes a little more sense to do it this way, and then I will finally ask you for an action at the end. To say that this situation is fluid would be an understatement. Beginning in January, when the governor proposed eliminating redevelopment, this agency has taken proactive action to stay one step ahead in protecting this community's resources and those assets of its redevelopment agency. Just to go over some legislative history, in January, the governor did propose eliminating redevelopment. There was some talk about compromise legislation that would allow redevelopment agencies to stay in existence, and then it went very, very quiet. Then later on in the budget season, the legislature adopted two bills, AB 1X26 and 27. We'll refer to them as 26 and 27. Interestingly, though, the governor had vetoed the rest or some other portions of the budget, so those did not go into effect. Legislature went back to work, and then on June 29th, with a budget bill that was adopted by the legislature, these two were signed and became effective. What they technically did was eliminate the redevelopment agency and then provide an option for redevelopment agencies to make a payment to reconstitute themselves. During that time, the agency has been well aware of what's going on. I hope the community is as well. As I said, you have taken several defensive measures. You entered into cooperation agreements, you issued bonds, you established a repayment schedule for long-term debt from the city to the redevelopment agency. Finally, on July 19th of this year, you adopted what we call an opt-in ordinance. That is, the city of Glendale agreed that they would pay the figure to reconstitute itself, and you did that as an urgency ordinance, making it effective immediately. Glendale was, if not the first, one of the first in the state, and as I'll get to later in my report, I think it's very important, again, that this agency has been proactive in this whole situation. Some of the areas of the legislation that come about is, first, this payment. How much do you have to pay the state to reconstitute yourself? In Glendale's case, it was about the Department of Finance estimated it was just around $11.8 million, and then about $2.6 million every year thereafter. The law provided that agencies could appeal that amount, and based on some debt that we issued after the time when they set the index for establishing this number, this agency had issued some debt. We appealed that number down to 10.7. So we filed our appeal with the state. We did it in a timely manner, and we believe that even if this legislation were to stand, that we would owe the state about $1 million less than what they originally estimated. The other section, or the other part of that, is the enforceable obligation payment schedule, and I'll touch on that in just a minute. Prior to all of this, the Supreme Court, where this challenge was initially filed, the Supreme Court stayed the legislation in 27 in its entirety and portions of 26. Unfortunately, it had the effect of freezing all of the agency's activities for new debt or new activities, things even that might change existing DDAs and owner participation agreements. The court then issued some clarification that really didn't affect that in any way. One issue that is very important to all of us is, what does that mean for those agencies that opted in prior to the stay? And that really wasn't clear. And as you look around the different counsel that we're getting from legal advisors, from our own city council, from those that are working for the League of California Cities and the California Redevelopment Association, there doesn't seem to be any real consensus as to what that means. What ultimately happened is yesterday, again, talk about a fluid situation. Just yesterday, the League of California Cities and the CRA petitioned the court and asked for clarification on that. What they're asking is those agencies, like Glendale, that opted in before the stay should be allowed to continue conduct their activities as they would have under the legislation. They went a step further and said for those that didn't opt in, you should still let them because there's really no harm, no foul if they do. And Ms. Van Meiden is prepared, if you have questions about that, to go into a little further. But without that clarification, this agency is frozen from any new activity. That activity can be anything from a facade grant or a home single-family rehab loan to agreements that we have with developers. One in particular, the Wilson, Maryland mixed-use project that this agency just recently asked that the scope be changed to include some underground parking. All of those actions we're kind of stuck and can't really pursue. We're looking at some ways that we might be able to do those things as a city. One of the actions that you took was in the event the agency can't do design review or environmental review, that authority be transferred to the city council. You took that back in March, I think. So we're at that point where some of the projects that come forward will look to the city to be the lead agency for their environmental review and the city to do their design review, this city council. So there are some projects that we can continue on. There are others that we still have to figure out a way to accomplish those things. Then finally, I'll go into what was the first item on your agenda, the enforceable obligation schedule. This is a schedule that's required of all agencies. And we've got to put on paper every obligation that we believe we had prior to this legislation becoming effective. So the schedule that I had transmitted to you yesterday, we have continued to work on that through the evening with staff from finance, from legal, and community development to try and list everything that we possibly think we have an obligation to pay. What you have before you that was passed earlier is that revised schedule, and I can go through that with you if you want.
Is the what schedule?
That is a revised schedule from what you received yesterday.
Right.
And Mr. Mnuchin, I apologize for not having an electronic copy. We literally were working on this right up until we came.
Well, it's considerably different than what was posted on the internet.
It is different, and I can walk through those changes if you like.
Okay.
Before I do, though, can I take care of some? The city attorney has asked me to take care of some housekeeping to give you some notices here. We're asking you to adopt the enforceable obligation payment schedule, which is that revised schedule that's before you. We will ask you also to authorize the executive director to post that on our website, which is required by the legislation.
The schedule?
That schedule.
Is this the final one?
That is the final one.
You sure?
I'm positive.
Tomorrow there will be another
As
one?
best I know. But you bring up a good point.
Because there's considerable amount missing here, and there's an increase. First, there's a page missing. The second page is missing. Second, there's some really old loans payable that are not on here. I don't know if it was consolidated into one line or not. And it's the initial one that was $335 million. And I'm only looking at the central Glendale project area. This is $373 million, so I guess you'll go through it later.
I will.
Okay.
I will. We're also going to ask you to direct that the final approved schedule that you do be sent to the Auditor Controller of Los Angeles County, the State Controller, and the Department of Finance. The effective date of this schedule won't be for 3 business days following the adoption of the motion before you. That is to allow for review by the county, the the auditor controller. The auditor controller. And then finally, Mr. Mnuchin, you did raise a good question. This can be, if we find that we have omitted something, we can come back to this agency and revise it and then resubmit that. Some of the changes that Mr. Mnuchin had referenced, first, I think the biggest one is from 4 pages to 3. What we did on this is the 4th page in the version that you received yesterday, we'll call that version 1. Those pages, that last page we called them other obligations. We have incorporated those into the place where those obligations are, Central Project Area or San Fernando. So they were for the most part, statutory pass-through payments. There's some that take place in Central. We've now included them on the page for the Central Project Area.
For the Central Project Area or San Fernando?
Both.
Both, so it's dispersed between the different project areas where it belongs.
Correct. And they are lines in the first page. They're down near the bottom. They are lines 33.
That explains the increase in the Central Glendale area, but why did you take out the old loan payments from 1977 and 1986, is it, that you have on here? In the old program, item 5 through 10, basically.
Go ahead.
In the old schedule.
Agency member Mnuchin, those city loans were combined into one lump sum, and I can point out the line item. They were
Could you
grouped
please?
together. Sure.
Is it the city loan agreement amended in June 2009 for $49 million?
Correct.
Okay. And that's fine. I just the overall issue of the obligations. Do we still have obligations from 1977? That's the question.
What we have
30 some odd years.
Yes, those were advances from the city, and that's what we've always referred to as the city loan. Those were advances from the city to the redevelopment agency that have been accruing interest all this time, which has actually worked to Glendale's benefit. But they still exist, and every year on our
Are those
annual
justifiable?
report.
I understand, but is it justifiable by law, and can we continue counting on those in terms of funding?
Yes, agency member Mnuchin, members of the agency, that's correct. Startup money is specifically authorized by redevelopment statute, and so that those loans were advanced by the city to the agency. Those monies were loaned by the city to the agency, and that was pursuant to authorization by statute.
Okay, have we made annual payments on these loans? And because if you loan someone money and you don't get monthly payments or annual payments, then it's not an arm's length transaction, and usually the government, the IRS, or another entity will void that transaction because it's not an arm's length transaction. Are we making payments on these loans, or is the city, I'll put it that way, is the city receiving funds from these loans?
We have made sure we've had a schedule of repayment.
Okay.
But as to the second part of your question, you asked, can we count on these? The answer to that is, we think we can, but there are provisions in AB 26.
So there's a gray area?
Absolutely. The state, frankly, if agencies were to be dissolved, the state has raised a question whether or not they would recognize these loans as enforceable obligations. And so, no question, there will at some point likely be further litigation if indeed these bills stand, of whether or not the state will recognize those previous loans as enforceable obligations for which you can use tax income monies for repayment. Now, believe me, there will be hundreds of redevelopment agencies that will join in that lawsuit, because these types of loans are very typical among redevelopment agencies. What the law provides is you can essentially defer your loan so that you can collect those funds, and at the end of your project's life, and then in effect then you extend your receipt of tax increment so you can repay those loans. It's sort of the last thing that gets paid off in the life of an agency. The state is attempting to limit it, however, in the way they define enforceable obligations.
That is a concern. Do these payments come to the general fund? Okay.
Well, they have generally come to the general fund. Payments have come to the general fund. They've gone under your CIP, various purposes you've done them for.
But it does come to the general operation of the city.
Yes.
Okay. All right. That is a concern if that goes wrong. And any other changes that we should be aware of? This is a very interesting schedule, actually. I was pleased to see the schedule so that we have a larger look at exactly what the obligations of the redevelopment agencies are. So I'm glad to see this. And it will be posted on the internet.
It will be posted on the internet.
When?
We will post it tomorrow. If you approve it today, we'll post it tomorrow. It will become effective in 3 days, which allows for some review. One thing that I would like to mention, Mr. Mnuchin, is that the number that you see there, and it's just around $1 billion of total debt outstanding. That represents another 15 years in the central project area and almost another 30 years.
But I want you to be careful when you say $1 billion of debt. A considerable amount is to the city of Glendale. It's not to bondholders.
That is correct.
Yeah, let's be clear. That is a great point that I think we need to drive home. These are enforceable obligations and payments by the agency that include debt as we think about debt. But they also include our obligations to pass through tax increment to other taxing jurisdictions. So when you see the number, it's not like we think of the mortgage on your home.
L.A. County School District.
L.A. County School Districts, the development agreement we have with Disney, all of those have obligations long-term in scope that we're obligated to pass through tax proceeds to those agencies. All of those have
Which is not per se debt.
Which is not debt per se. It may be debt as defined in redevelopment law, but not debt as we think about it.
Right.
And that's the main distinction.
Very important point.
It is defined in redevelopment, but not as we typically know that.
And
what is here represents what is defined in redevelopment.
Right. And do we have a breakdown of how much, and I can go through and add up one by one how much debt redevelopment agency owes the city. Do we have a total number on that?
Well, it's about $74 million, $72 to $74 million. Now,
To the city by the redevelopment
to the city
agency.
by the redevelopment agency. That's in both redevelopment project areas. Earlier this year, we made a repayment of about $32 million. Again, that was an action that you took.
Payment by the redevelopment agency to the city
To the
of
city.
$32 million?
Correct. And that was a defensive move on the agency and city.
So that decreased the debt from 74 to something to 37?
It would decrease it by that number.
Can I?
That's why in the schedule you see a number that's a little above $40 million. or so.
Correct.
And these figures will correspond to what's on the financial statements
Yes.
for the redevelopment agency?
For those things that are reported in the financial statement, yes.
If I can, let's be clear. This is a schedule of enforceable obligations, not necessarily debt.
Not all of it.
No. So, for example, you look at the CAFR on the balance sheet, and all the debt that you see on our CAFR and audit statements will be reflected here. But a lot of what's reflected here won't be on there because it's ongoing payments in the upcoming year that we have an obligation for that are not necessarily debt.
I would like to request actually not to post, if this is sufficient to post and to present to the state, that's fine. But I would like to have separated the amount that is owed to the city, the amount that is passed through on the true debt to the redevelopment agency separately.
What we can do is, because they are separated, we can highlight those and make footnotes indicating which ones they are, because all those numbers are on here.
No, I know. That's why. I mean, it's a spreadsheet. All you have to do is resort it and subtotal it.
Yeah, we can pull them out.
If you can do that,
we will do that.
Otherwise, I'll have to enter it in the spreadsheet myself.
No,
and I might charge you guys for it.
If you tell me what color you like, we'll highlight it.
Right.
We'll use a yellow or a note or something. I would finally like to say that this is a summary spreadsheet. This is what's required by the law. We will have backup to all of this so that in some cases we have consultant contracts.
Well, you have to have backup for all of this, right?
Mm-hmm. Yeah, but we will have it. We're looking to post it, or at least so you have a roadmap that you can break this down.
What happened to Frank?
Maybe his eye was bothering him.
Oh, okay. Is he okay?
Hopefully.
Okay.
So with that concludes our presentation. I would like to note Elena Bobolian really has worked hard on this to get this in concert with the city attorney's office, both Ms. Van Buyden and Mr. Garcia, and truly appreciate that. This is the basis for what the agency will be able to do going forward should the court decide certain ways.
And has finance signed off on this as well?
We have been working with finance as well.
Because you left them out, everyone else has worked on it.
I know it.
Except
My
finance,
apologies.
and
You tend
I
to-
was just curious to see
tend
if
to
they
do
were
that.
involved as well.
Yes, they were.
Okay, very good then. Any questions, any other questions from agency members? Okay, can I have a motion?
Actually, I do have a quick
Okay.
question. I got a little confused when you were talking about how the freezing of the agency activities is affecting various projects. It's specifically in regards to the Lemley-Wilson project.
Why do you
I wasn't
call it
sure
that?
whether you were saying that the entitlements, that we'd have to sort of shift how we do some of the entitlements because the redevelopment agency couldn't do that any longer, or whether you were saying that the commitment that the redevelopment agency made in terms of the land, that that's in jeopardy at this point.
The law specifically precludes us, the redevelopment agency, from disposing of land.
Even though that was done before they passed their bill?
Yes, and I'm going to turn to my counsel on it.
Van Muyden?
Part of the legislation that was not stayed allows the agency to continue to, pursuant to its enforceable obligations, to make payments, enforce existing covenants and obligations, and to perform its obligations.
Isn't that an existing obligation?
That is our interpretation of it.
The real problem...
Is there a cutoff date? That's the question.
Getting to the crux of the issue, the real problem with that project that we're looking at is our ability to amend the development agreement to include the underground parking.
So, okay,
So the
because to me
project-
that's, I mean, I understand that's important, but that's a little more of a technicality perhaps than...
EDA that the council approved or the agency
Is
approved
valid.
is enforceable.
But remember, we came back and said we wanted to include a level of underground parking.
I
The problem
understand.
is, how do we get that done? How can we make that amendment to include the parking? Because you hadn't gotten to the point of approving a full development agreement yet.
Okay.
And that's...
So that portion could be in jeopardy.
Yes, and that's a great example of the complexity of some of these issues. That first piece should be okay. The second piece, though, is, okay, now how under this stay can we accomplish the second piece?
And do we have ideas of how we can accomplish that second piece?
We're working on it, but we
Working on
shouldn't
it.
get into it here.
Okay, that's fine.
Let's just say we're looking at every one of the projects and activities of the agency to look and see which ones are impacted by the stay and what we might be able to do in order to continue to make progress. And on that, it's important to note something that Phil mentioned, but I'll highlight it. The CRA and League have filed a motion for clarification and modification of the court's stay provisions, and it's really in two parts. One is to allow those agencies that previously adopted the ordinance to opt in to proceed, and they have a whole list of justifications why that should be able to occur. The second part, and I'm hoping when the court makes its decisions it'll do it separately, because I'm a little concerned if we get lumped in with the second part. The second part is they've asked for agencies that had not as yet adopted their ordinances to opt in, because you had until November to opt in, I think, November 1st to opt in. Many agencies had not adopted their ordinances yet, and so there's a question, can those agencies proceed to adopt ordinances, as a result opt in and be out from underneath the stay? Now, if the court's determination is positive in both respects, then frankly all this concern about the second phase of Lemley will go away and we can continue operating as normal. If it isn't, we're going to have to look at the implications of that on all of our projects.
Well, that's also confusing to me because I thought that the reason we paid the blackmail money was so that we could continue. But now I'm being told that some of those programs, like the facade grant programs that are so helpful to our businesses, can't continue. So what did we pay the money
Well,
for?
You haven't paid the money yet.
You've just very nicely summarized the argument as to why those agencies that opt in should be allowed to continue. Because the agencies that opted in, if the legislation is deemed to be valid, they opted in, they should be able to proceed. If the legislation isn't valid, then there would have been no reason to opt in and we should have been able to proceed. So that's kind of the argument from the attorneys, because in reality the court was attempting to say let's maintain the status quo so nobody's harmed in this process until we decide the outcome of 26 and 27. The reality is, and there's a filing by the city of San Diego, there will be irreparable harm done to many agencies, including us, if all activities are suspended. We don't think that's what the court intended. That really puts cities and agencies and projects in a disadvantage. So that's essentially the argument that the attorneys are making for this modification of the stay.
And I would just add, Mayor Friedman, that the timing schedule that the court has put in place with respect to this case was so that they have a final decision before the cities actually have to pay in the opt-in money.
Your payments are January 15 for the first half and May 15 for the second half. The state did indicate it planned on ruling on this prior to January 15. Now, in the meantime, though, as we know, many, many projects throughout the state and hundreds of millions of dollars will be lost if this suspension remains in place. So we're hopeful we'll get a favorable ruling from the court on the modification.
Not including the job losses.
Oh, all of that. I mean, frankly, the motion filed by the attorneys does a very nice job of setting out the potential implications statewide. If the court thought it was just keeping everything in place, nobody benefits, nobody's disadvantaged. The reality is the suspension disadvantages many, many agencies and many, many important projects across the state. Something that we think the court hadn't realized and was unintended.
So maybe the people without jobs will go up, what, 13, 14%? That'll make Sacramento happy, what they've done to themselves.
Okay, so the motion was,
Move 6A1.
there was a... Second. There's a motion and a second for 6A1. Roll call, please.
Agency members Friedman,
Yes.
Najarian, Quintero,
Yes.
Weaver,
Aye.
Chairman Menuchyan.
Yes, and we have a motion at 6B.
There-
It's an oral
no-
report only, okay. What is next, please? Agency member staff comments? Anyone have any comments? Staff? No? Okay, can we adjourn?
We adjourn.
We are adjourned.